take my shoe off?
Yes.
Bang it? Gavel? No. No. Sorry, I wasn't there.
Just give them 1 second. We're going live at 10:50.
Okay. Thank you. My name is Marissa Darden. I'm one of the executive editors on the Duke Journal of Comparative and International Law. It's my honor today to introduce our moderator. Professor Donald L. Horowitz is the James B. Duke Professor of Law and Political Science here at Duke. He's the author of 6 books and is currently writing one about constitutional design, particularly for divided societies, a subject on which he has advised a number of countries. He's also currently the president of the American Society for Political and Legal Philosophy and was recently appointed to the Secretary of State's Advisory Committee on Democracy Promotion. Thank you, Professor Horowitz.
Marissa forgot to tell you that nobody ever takes the advice that I tender. But today, the panelists will. And I'm pleased to introduce them. They're each going to speak for 20 minutes, and that will give us, I hope, plenty of time for conversation. Professor Thomas Carbonneau is at the Penn State Dickinson School of Law, and actually we've just been talking about the interesting need of Penn State and Dickinson to produce a single school of law out of 2 campuses, which is a fascinating topic, but I don't think that's what he's going to speak about today. Yes, right. And Professor Charles Brower is professor at the University of Mississippi School of Law. And by the way, you have, if I read these biographies, I would steal their time, and I don't intend to do that. There are detailed biographies in your packet. And then Chris Whytock is at the University of Utah School of Law, and the only thing I'll say about him is that he is a recently minted PhD from the Duke Political Science Department, but please don't hold that against him. So, please.
Let me say a few things at the outset. I'd like to thank the journal staff for the remarkable job they've done organizing the event. So it's been a very convivial affair already. I'd also like to make a few preliminary remarks to a couple of the speakers that preceded us. One is I disagree relatively strongly with their interpretation of the Mitsubishi case. I think it simply provides for the enforcement of arbitration agreements and also says that statutory inarbitrability doesn't apply. It certainly doesn't command the arbitrators to resolve any statutory disputes, unlike apparently the European practice indicates. I'd also like to say, listening to one other speaker, that the problem of public international law, I had a choice between that and private international law 30 years ago when I worked at UVA for Richard Lillick, and I'm glad I went private instead of public because the problem is one of lack of jurisdiction. I mean, you can talk about all of these various manifestations of what the law could be, might be, etc., but it reminds me of a lava lamp that keeps flowing these large concepts around that don't ever fall anywhere. So the problem of jurisdiction is very befuddling and frustrating from a private lawyer's perspective. And because you don't have jurisdiction, you don't have finality. And if the legal system can't provide finality, I'm afraid it's not a legal system at all. So that's certainly a disagreement with that approach. I agree that law reflects values, culture, and power, and it's primarily a power instrument that formulates rules of conduct that are binding, and if it doesn't do that, it really doesn't serve any useful function. As to the distinction I want to begin with, public and private disputes, I don't share the intellectualizing view that somehow this is riddled with difficulties and questions and problems that are metaphysical in character. I think the intellectualizing simply makes the practice of law more difficult. I think the private-public distinction is manifest. The definitional contours are well established and should be respected. And I think the point of my paper is that political disputes are not able to be harnessed by any remedial mechanism, including arbitration, unless the disputing parties want that to be the basic result. I'm going to speak to you about arbitration. I don't know if I'll go the full 20 minutes, but I'm going to discuss how arbitration could be a solution to public international disputes. It certainly is a solution to private international disputes and has been for some period of time. Arbitration, as you know, is an agreement by contract to submit disputes to a group of arbitrators. It is private dispute resolution. It is contractually founded. The two hallmarks of arbitration in its new reinvigoration since the Second World War and since the fall of the wall in 1989 have been adaptability and adjustment. It can be manipulated to respond to developments, to new and emerging situations. The current issue in international domestic arbitration law from a U.S. perspective is tribunal-wide neutrality of the arbitrators, for example, and that is meant to legitimate or legitimize, I guess, arbitration even more. The force of arbitration is now guaranteed by the U.S. Supreme Court. The U.S. Supreme Court has given us, both domestically and internationally, a private system of adjudication that actually works and contains the mouths of lawyers such that it yields binding solutions. The French Court of Cassation was the first to do this. The French, just to refer to another remark made earlier on about Berthold Goldman, who was a very distinguished international arbitrator, and his mind was very creative and did form most of the Lex Mercatoria at that stage. But the French Court of Cassation and the French government rather ratified the New York Arbitration Convention about a year after it was open for signature. So the French have been very interested in international arbitration. In roughly 1970-72, the U.S. Supreme Court picked up the mantle or picked up the baton and has been running with it ever since. The U.S. Supreme Court, in effect, through a variety of some 30 cases, has established a second civil litigation system that works, and it works domestically and internationally. And on the domestic side, it deals with contract, consumer, employment, maritime disputes, at least until the U.S. Senate enacts the Arbitration Fairness Act of 2007, which will be a catastrophe to arbitration. And I'll speak a little more about that a little later on. But arbitration does things that the regular litigation process, judicial litigation, can't do. It is efficient, it is expert, it is expedited, it is economical, despite what Ralph Nader says about it. The savings in attorney's fees make it much less costly than equivalent litigation before the courts. It is fair, it is final, and it is flexible, and it has a huge track record in terms of commercial dispute resolution. It functioned firstly and most effectively in the international area, dealing with commercial transactions. It stabilized, civilized the international marketplace. It established a rule of law that actually could be defined and implemented, unlike some international treaties. It even rose to dealing with not just contract disputes, but statutory and regulatory disputes in that process. It has achieved in the international area a remarkable reconciliation of competing legal traditions. I spent over 20 years in New Orleans in a mixed civil jurisdiction where the argument was which prevails. Is it the civil law, which actually was non-existent, or is it the common law? And when you're there for that period of time, you realize that reconciling cultural predicates is a very difficult, if not next to impossible thing to do. International arbitration inside the process has reconciled common law and continental civilian methodology better than anyone could have actually anticipated. In addition, arbitration has yielded norms of law that actually are workable norms of law that actually decide international commercial cases. So in effect, on the international side, you have de facto a fully functional system of adjudication that is procedurally sound, it has due process, and that also is a vehicle for the generation of international commercial law principles that have actual application. All of this without state authority. All of this being done in an absolutely private way without state sanction. In terms of applying arbitration domestically, it's a little more difficult because there is not the vacuum of no rule of law whatsoever, and your only choice is municipal court litigation, which is a catastrophe on its own that doesn't get you either to fairness or finality. But on the domestic side, arbitration is much more problematic of application because it raises questions about fundamental legality. And that's where the Arbitration Fairness Act of 2000 comes in. Is the arbitration agreement an enforceable contract sufficiently fair? If it is adhesionary and imposed by the stronger party, written by the stronger party, and ultimately, I guess, may tendentially support the stronger party more than the weaker party. That's the sense of the Fairness Act of 2007. It basically makes illegal mandatory arbitration provisions in employment, consumer, and franchise cases. And it also robs arbitrators of the ability to decide the enforceability of contracts, which is called competence. Competence to fancy Europeans. It's much less fancy on this side of the Atlantic. But ultimately, it says that that jurisdictional power doesn't exist in these cases for arbitrators, which is a very substantial restriction of the standard autonomy of arbitrators. So there is discussion and debate about the domestic future of arbitration as the second system for civil adjudication, the second system that is the workable system and not the first system. It also raises questions about waiver of class action and whether there's a specific paragraph in the 2007 Fairness Act that says that arbitration is not a proper means of deciding civil rights cases. And that goes directly to subject matter inarbitrability, which is Mitsubishi, and then it's McMahon, and it's Rodriguez, a set of very critical opinions decided by the U.S. Supreme Court. Whether arbitration survives on the domestic side, which the Act threatens its viability, will depend on who wins the great contest that is now being elaborated for early November 2008. So it's, I think, a precarious time for arbitration from a legislative point of view. There is no doubt, however, that the U.S. Supreme Court believes that arbitration is absolutely vital to due process in American society. It is also an exclusive vehicle for establishing justice standards in the international marketplace. There may be ways to address this other than through castrating legislation. And that may be to certify arbitrators, to regulate arbitrators, to provide for greater judicial supervision of awards that decide statutory controversies or things like that. But it is certainly a very risky thing to try to do this by legislative means. A next important point, and almost the final point of my presentation, is that political disputes are unresponsive to arbitration. They certainly are different in their response than commercial disputes. The autonomy and independence of states demands that there never be finality until the state accepts it or until both states accept it or all states accept it. The relationship between states is adversarial, competitive, destructive. Sovereign privilege frustrates the rule of law at an international level. That's why you have all this talking. The only UN instrument that I know that has ever been workable is the 1958 New York Arbitration Convention. No other international instrument has been ever separated from sovereign discretion. So on the international side, and I go into detail about this in the actual paper, sovereign privilege makes it difficult to establish a rule of law. There is a need to win, and to win absolutely in every situation, and usually military engagement and war resolve those disputes with finality, at least temporary finality. Arbitration, however, has made some inroads into political dispute resolution. NAFTA is one of them, is one illustration. The Iran-U.S. Claims Tribunal, of which your dad was a very prominent judge for a number of years, is another. And you also have the ICSID Convention, the World Bank Convention, which has been rejuvenated by references in treaties to that process. And ICSID arbitration, World Bank arbitration, is instrumental to the rule of law in Latin American countries. And there are highly politicized disputes dealing with natural resources, water, hydroelectric stuff, oil, concessions, etc. And ICSID arbitration has been applied to those situations. And one issue that has arisen recently is whether you can get amicus briefs filed in international arbitral proceedings. That's an issue of some contention, but there have been some inroads into the political disputes from the perspective of arbitration. Perhaps just to illustrate the problems with NAFTA arbitration, there is the famous Metnex case in which a group of NAFTA arbitrators ruled that a California regulation banning the use of a particular chemical in gasoline in California violated the NAFTA treaty because it eviscerated the business of a Canadian company. And the Canadian company filed suit and claimed that although California was sovereign in what it could do, it had to pay for the commercial consequences of the exercise of its sovereignty. I thought that was a really nifty idea, but apparently left-wing America did not, and somehow that got reconsidered, right? Or
The Methanex Tribunal dismissed the case on jurisdiction.
Right, yeah, they did that jurisdictional trick, and ultimately didn't decide the way they should have decided. But I think as a lawyer, I've always worried about how you deal with states. 15 years ago, there was some Louisiana company that had a contract with the Ministry of something in China, and they wanted my opinion on what they should do. And I said, stay the hell away from it because you can't contain sovereign discretion. And they were going to occupy most of their production for the next 3 years, and I thought that was a dangerous and risky thing to do. But dealing with states in international commerce is a very difficult animal to corral, and it is arbitration is not as workable. So I think there is in arbitration a private perspective. I think it has been very effective in generating a rule of law in private business dealings. It's made a huge amount of money for international arbitrators, many of whom are multimillionaires, because these are big business deals. It has made global business and global prosperity possible. The reach of arbitration, the effectiveness of arbitration in terms of political dispute resolution is much lesser. So with that introduction, I'll leave it to you to respond.
Admirably concise.
Okay, well, first of all, thanks again to the organizers for inviting me. And as someone who's just starting to focus on arbitration, it's especially great to have the privilege of being here with Professors Brower and Carbonneau. My paper is called, and thanks to Professor Horowitz as well for moderating our panel. My paper is called Litigation, Arbitration, and the Transnational Shadow of the Law. And my twin points of departure for this paper are these. The first is my interest in understanding the role of domestic courts in global governance, which I'll call transnational judicial governance for shorthand. And in my dissertation, actually, I argued that for better or for worse, domestic courts play an important role in global governance. My second point of departure is this widely understood proposition that arbitration is replacing litigation as the leading method of transnational dispute resolution, at least for transnational commercial disputes. Some political scientists, including Alex Stone-Sweet and Claire Cutler, have argued even more broadly that the rise of arbitration, together with the use of non-state norms, such as the lex mercatoria, constitutes a new form of transnational private governance, one that's challenging public forms of governance like transnational judicial governance. So this leads me to ask two questions. The first is, how sound is the empirical basis for the proposition that arbitration is replacing litigation? And then second, if arbitration is indeed replacing litigation as a method of transnational dispute resolution, what are the implications for transnational judicial governance? Does it mean that domestic courts are playing a decreasingly important role in global governance? Or might it actually suggest that transnational judicial governance is more than ever playing a foundational role in the regulation of transnational activity? And before trying to explain how I went about answering these questions, let me begin by suggesting that there are two ways that we can look at the relationship between domestic courts and arbitration. And the first is that we can look at the relationship from a disputant-oriented perspective. And from this perspective, the focus is on the implications of the relationship for the parties to particular transnational disputes, and viewing litigation and arbitration as alternative forms of dispute resolution. And the choices are, and these are strategic choices that the parties make based on the relative advantages and disadvantages of these forms of dispute resolution under particular circumstances. Alternatively, and this is what I try to do in my paper, we can look at the relationship between domestic courts and transnational arbitration from a governance-oriented perspective. And from this perspective, litigation and arbitration are not just alternative forms of dispute resolution, but they're parts of alternative systems of global governance. That is, systems that aim to set, apply, and enforce rules of transnational activity. And for me, this perspective has two key characteristics. First, it looks at the implications not just for the individual disputants, but for transnational actors more broadly. And to help explore these implications in my paper, I take Robert Mnookin's and Louis Kornhauser's well-known shadow of the law metaphor, which they use to try to elucidate the role of divorce law and court decisions on the behavior of divorcing couples outside the courtroom. And I'll extend this to transnational law and transnational activity. Second, the governance-oriented approach looks not only at doctrinal analysis of the relevant rules of transnational law, including the domestic and international law of arbitration, but also at what courts actually do, or at what Roscoe Pound called law in action. We have a tendency to focus on the big Supreme Court precedents in this area of the law, and I think there's a lot to learn from what the trial courts on the front line of transnational litigation are actually doing. So I'll deliver the rest of my remarks in three parts. First, I'll suggest that maybe transnational arbitration is not as pervasive as is commonly believed. And then second, even assuming for the sake of argument that arbitration has essentially replaced litigation as the method of choice for transnational dispute resolution, I think this might actually be evidence of the continuing important fundamental role of domestic courts, that they perform a support function, a governance support function that allows this arising system of private governance to function. And finally, I'll touch, if I have time, on some broader implications of these points. Okay, so first, is there a shift from litigation to arbitration as a form of transnational dispute resolution? And our intuitions would suggest that if there is a shift, it's primarily going to be in the area of contractual relationships, because we usually don't have ex-ante agreements to arbitrate in tort cases. But beyond these intuitions, what data is available to test them? And the bottom line is the data is quite limited. First, regarding litigation trends, is transnational litigation on the decline? And the available evidence suggests that, that litigation is alive and well. And in 2005, according to data collected by the Administrative Office of the U.S. Courts, more than 250,000 civil cases were filed in the U.S. federal district courts. And according to data collected by the National Center for State Courts, approximately 16.6 million civil cases were filed in U.S. state courts. And the data also shows that overall civil litigation rates have increased in the last decade, both in the federal and the state systems. But of course, we can't assume that these trends are necessarily mirror those of transnational litigation. And here the data is even more limited. The Administrative Office data shows that there's been actually a substantial decline in the rate of alienage cases filed in U.S. federal district courts. And that is cases that are over which the federal courts have jurisdiction because of the disputes between citizens of a U.S. state and a foreign state. But there's not available data on other types of transnational litigation. And what about transnational litigation over which the courts have jurisdiction on the basis of a federal question? What about disputes between two U.S. citizens arising out of cross-border activity? And then finally, I think this is the biggest gap in our knowledge, is what about transnational litigation in state courts? So we have an awful lot to learn about transnational litigation rates. And then how about on the transnational arbitration side of the equation? And here, at least the conventional wisdom is very well established, that, that there's been a dramatic rise in transnational arbitration in the last decades. But increasingly, scholars are starting to realize that our empirical knowledge about arbitration is quite thin. On the one hand, there is indeed substantial evidence that transnational arbitration is on the rise. And data collected by Alex Stone-Sweet, for example, shows that the number of transnational arbitration houses have grew from only 10 in 1910, to more than 100 in 1985, and today there are at least 150. Between 1920 and 1980, over this whole 60-year period, 3,000 disputes were filed for arbitration at the International Chamber of Commerce. During the 1996 to 2005 period alone, more than 5,000 disputes were filed with the ICC. Stone-Sweet also states that more than 90% of all transnational commercial contracts contain an arbitration clause. So on the one hand, we have this powerful evidence that transnational arbitration is indeed quite pervasive. On the other hand, there's emerging evidence that suggests that it might not be quite as pervasive as the conventional wisdom suggests. There's a 1997 Cornell University survey study of Fortune 1000 companies that was analyzed by Thomas Stepanowicz in a Research Journal of Empirical Legal Studies article. 32% of the respondents indicated that the presence of a non-U.S. party in a dispute is indeed a reason to pick arbitration over litigation in a transnational dispute. But the results show that only 21% of Fortune 1000 companies, many of which presumably engage in a lot of transnational business transactions, use arbitration frequently or very frequently. And 38% of these companies said that they use arbitration rarely or not at all. More recently, Theodore Eisenberg and Jeffrey Miller have analyzed 2,800 contracts filed with the SEC in 2002. They found that only 11% of them contained arbitration clauses, and only 20% even of international contracts, contracts involving at least one non-U.S. party, only 20% of these contained an arbitration clause. So at least they conclude, I'm not sure they can necessarily reach the conclusion based on this evidence, but they really challenge the proposition that transnational arbitration is as pervasive as we tend to think. But the fact that we have estimates on the one hand that 90% of contracts, transnational contracts, include arbitration provisions, and other evidence suggesting that only 20% do, I think shows how much we have to learn about transnational arbitration. But I think there are at least two possible explanations for these this divergent data. And one is that maybe some of the people doing these studies tend to overstate or overgeneralize the advantages of arbitration over litigation. And strategic actors will often find it more advantageous to try to push for litigation. And if this is the case, maybe we have a tendency to exaggerate how pervasive it is. But I think a more intriguing explanation is that there may indeed be an emerging arbitration-based system of private transnational governance, as Stone Sweet argues, but one in which U.S. parties simply don't participate as widely as European parties. The studies cited by Stone Sweet are largely based on European data. In contrast, the Cornell study and the Eisenberg and Miller study is based on surveys of U.S. companies and U.S. SEC filings. And data collected by Walter Matley, another political scientist who's done some work on arbitration, provides a little bit of support for this speculation. He found that since 1974, about 60% of the parties involved in ICC arbitration were from Western Europe, where only 10% were from the U.S. Part of this may be the geographic location of the ICC, but maybe it does support this difference between U.S. and European practice. Okay, but let's assume for the sake of argument that arbitration has essentially replaced litigation as a form of transnational dispute resolution. The thing is, this wouldn't necessarily imply a decrease in the importance of transnational judicial governance or an opportunity of transnational actors to escape the transnational shadow of the law. Whether we draw these implications depends on the relationship between domestic courts and transnational litigation. Particularly, it depends on the extent to which transnational arbitration as a system of private governance itself depends on foundations provided by transnational judicial governance. And at least in political science, there's what Stone Sweet describes as a war of religion between traditionalists who argue that, of course, there's this very essential reliance on domestic courts to support arbitration. And then there are people he calls the proponents of transnational arbitration, the lex mercatoria, who argue that, no, we have a system that really is fundamentally autonomous from domestic courts and from the state. And I want to try to provide a slightly more nuanced intermediate understanding of this relationship. First, I think it's important to remember that the architects of the transnational arbitration system themselves recognize the foundational role of domestic courts, both as facilitators of the system and as monitors or supervisors of the system. And I think the facilitating role comes out of Articles 2 and 3 of the Convention, of the New York Convention, when it creates a presumptive rule of enforcement of agreements to arbitrate and a presumptive rule in favor of enforcement of arbitral awards. And then Article 5, I think, can be understood as at least giving courts the option to exercise a monitoring role and allowing them to decline enforcement, for example, if doing so would violate public policy. Over time, however, I think it is fair to say that transnational arbitration has acquired a considerable degree of autonomy from the state, and I think the key is to focus on the nature of this autonomy. On the one hand, U.S. courts have, for the most part, declined to engage in significant monitoring or supervision of transnational arbitration. And, for example, the Mitsubishi case says that substantive review of arbitral awards, even though it announced the second look doctrine, this review must remain minimal and it cannot be intrusive. And in the Second Circuit in Parsons and Whitmore overseas held that the public policy exception has to be construed very narrowly and applied only where enforcement would violate our basic notions of morality and justice. So it seems safe to say, at least tentatively, that transnational arbitration is indeed quite autonomous from judicial monitoring. On the other hand, and I think this is consistent with the traditionalist view, transnational arbitration generally is not autonomous from domestic courts when it comes to enforcement. But I'd add two nuances to this traditional understanding of arbitration's dependence on judicial enforcement. And the first is that arbitration agreements and awards do not, of course, necessarily go unheeded just because there's no judicial recourse. Rather, the Supreme Court's strong pro-enforcement policy, because of that strong pro-enforcement policy, transnational actors expect domestic courts to ordinarily enforce these agreements and awards, and I think they're therefore more likely to comply with them voluntarily. And I think the key here is that it's by creating these expectations, more by creating these expectations than by enforcing arbitral awards on a case-by-case basis, that domestic courts provide this support for arbitration as a form of transnational private governance. And I think it's in this sense that not only disputants, but the whole system of transnational arbitration arbitrates in the transnational shadow of domestic law. Some scholars, and this is a second nuance, some scholars, Bruce Benson and Alex Stone-Sweet, have argued that private enforcement without the existence of the shadow of the law may be possible on the basis of reputational sanctions. And their argument is that under certain conditions, these reputation-based enforcement mechanisms may allow arbitration-based transnational governance to gain autonomy not only from judicial monitoring, but also from judicial enforcement, which is something that traditionalists may not appreciate. The problem is that reputational sanctions are only likely to be effective in a narrow set of circumstances involving adequate information about how others are behaving, and also sufficiently long time horizons. And I think this suggests that outside the shadow of the law, transnational arbitration is likely to be an effective form of global governance only in relatively small, well-defined and enduring communities in which parties have long time horizons and are able to monitor each other closely. And elsewhere, I think the role of domestic courts in facilitating transnational arbitration is going to remain essential. From a governance-oriented perspective, then, I think the rise of transnational arbitration might in fact vindicate transnational judicial governance by suggesting that even if domestic courts aren't playing the same direct dispute resolution role that they once played, the importance of their governance support function might be increasing, and you might even say that it's to a large extent responsible for the success of transnational arbitration. Looks like I have a couple minutes just to draw out a few quick implications. So on the one hand, transnational arbitration is largely autonomous from judicial monitoring. On the other hand, largely dependent on facilitation by courts through judicial enforcement. What are the implications of this relationship? First, if there is indeed an emerging system of transnational private governance based on transnational arbitration and the new Lex Mercatoria, I think it's only partially autonomous from transnational judicial governance. And for the most part, as I mentioned before, I think it's likely to be effective only in the transnational shadow of domestic law, except under conditions where these reputational private enforcement mechanisms can work. Second, I think it follows from that when we talk about transnational arbitration as a form of global governance, that it's probably better characterized as a form of a mixed public and private form of governance than a purely private form of governance. And for that matter, transnational litigation is not purely public because it's private parties that initiate it. So maybe we should not think in these really hermetically sealed dichotomies. Third, the combination of judicial facilitation through enforcement and what one might call judicial abdication of monitoring is really what's given rise, I think, to the normative concerns that are out there about the regulation of about arbitration and concerns about whether arbitration can sufficiently regulate the negative externalities of transnational commercial activity. And this might mirror a little bit of maybe another way of phrasing some of Professor Carbonneau's concerns about cases that involve statutory issues. And one response might be at least to conceive of this problem as one of negative externalities, and maybe even to explore, and I'll stick my neck out a little bit, but to say it's very tentatively explore the possibility of bringing some of these notions of negative externalities into our thinking about what the public policy exception under the New York Convention might mean or what it should mean. And then finally, I think we do need to know more about transnational arbitration and litigation to answer really any of the questions I've raised with any confidence. And so I think it would make sense to continually try to subject our intuitions about these matters to more systematic empirical evaluation. I think we need to know more about litigation and arbitration trends over time. I think it would be helpful to really look at what domestic courts are actually doing on a widespread, systematic basis, identify patterns. How much do we know about the actual rates of enforcement? How much do we know about the rates at which exceptions to enforcement are invoked? And then I think it's also going to be important to do more comparative work to further test this possibility that we might really have two different approaches, a European and a U.S. approach. And then finally, from a governance-oriented perspective, I think what might be more interesting than trying to defend arguments about whether, about the primacy of courts versus arbitral tribunals in transnational relations, I think it might be a lot more interesting to start really digging into this complex relationship between these two forms of dispute resolution and two forms of governance, and the relationship between public and private authority in general. And I think this can lead to some really far broader insights about the relationship between public and private authority in global governance. Thanks.
Thank you. For private commercial disputes, the shift from litigation towards arbitration has become so ingrained in the public consciousness that many have ignored an important counter trend. And this is for controversies among states involving the exercise of sovereign powers and the application of public international law. Dispute settlement has taken the opposite course, from arbitration towards judicial settlement. Seeking to throw light on this neglected topic, my remarks will first review 4 landmarks in the decisive shift from arbitration to judicial settlement of interstate disputes. And so you can follow, these will be the Jay Treaty, the Alabama claims, the Hague peace conferences, and then the establishment of a world court. Second, I aim to identify the functions and limits contemplated by the architects of that movement towards judicial settlement. And third, I want to use those insights to explain the otherwise puzzling reluctance of states to embrace an element of judicial settlement in the context of investment treaty disputes. So in recounting the development of international tribunals, one must begin with the Anglo-American Jay Treaty of 1794, which established 3 arbitral commissions to determine the northeast boundary of the United States, to resolve the claims of British creditors who remained unpaid due to wartime measures adopted by the former colonies, and to settle the claims of U.S. citizens for the unlawful detention of ships and cargo by His Majesty's Navy on the high seas. While the first commission reached a unanimous decision, the second broke up over emotional quarrels among the commissioners. The third nearly broke up, but then righted itself and resumed its work, rendering 530 awards worth nearly $12 million in the course of 8 years. The significance of the Jay Treaty Commissions lies in their revival of arbitration, which had fallen into disuse during several centuries of European conflicts. Furthermore, departing from the practice of unreasoned awards rendered by sovereign arbitrators, they afforded the first prominent example of arbitration by collegial tribunals issuing reasoned awards based on the application of legal principles. However, because they consisted entirely of citizens unilaterally nominated by the disputing parties, the Jay Treaty Commissions saw their mandate as the extension of diplomacy. And furthermore, their rules of procedure reinforced that orientation by requiring the presence of at least one party-appointed arbitrator from each side to transact any business at all. As a result, the party-appointed arbitrators held a collective veto over any issue which they could exercise simply by withdrawing from the proceedings, bringing them to a temporary or, in one case, permanent halt. And needless to say, this sort of arrangement encourages commissioners to blend the demands of justice with the expediency of diplomacy. Despite the Jay Treaty's revival of arbitration, many writers regard the Alabama claims as the greatest arbitration in history. Commenced under the Treaty of Washington of 1871, that arbitration concerned British violations of neutrality involving the construction of armed vessels for the Confederacy during the American Civil War. And while it sounds almost incredible to the modern ear, That controversy brought the states closer to the brink of war than at any time since 1814. After years of unsuccessful negotiations, the United States and Britain finally agreed to submit the claims to a tribunal of 5 jurists to be appointed by the President of the United States, the Queen of England, the King of Italy, the President of the Swiss Confederation, and the Emperor of Brazil. After conducting hearings in Geneva during the summer of 1872, that tribunal rendered an enormous award for the United States, which the British government satisfied by tendering U.S. bonds that had been issued to finance expenses during the American Civil War. Now, reviewing its significance, many writers emphasize that the Alabama Claims Arbitration removed a cause of war between 2 great powers, thus proving the capacity of arbitration to resolve controversies of the first order. But more importantly, for the development of international tribunals, Britain and the United States did not merely resort to arbitration, they altered its character. Instead of establishing a quasi-diplomatic joint commission or submitting the dispute to a sovereign arbitrator, which had been the British preference, they consented for the first time in history to arbitration before a panel of jurists appointed mostly by neutral powers. And following the success of the Alabama Claims Arbitration, demand built for arbitration conducted on a more judicial model. Thus, when Tsar Nicholas II convened this First Hague Peace Conference in 1899, a worldwide movement already favored the establishment of a permanent international court. As a result, several delegations received instructions to make proposals on the topic. For example, the United States favored a permanent court continuously sitting and staffed by eminent jurists. Russia added a plan to make arbitration mandatory for certain disputes, but Germany opposed all of those proposals because its army had a unique capacity to launch preemptive strikes in a matter of days. And under these circumstances, Germany feared that potential targets would use the slow machinery of arbitration to buy time and therefore neutralize its military advantage. Now, to a large extent, German resistance explains the package of half measures adopted by the Convention on the Pacific Settlement of International Disputes, which created a so-called permanent court of arbitration that has no compulsory jurisdiction, that has no permanent bench, and that merely comprises a list of arbitrators, a small secretariat, and a set of procedural rules. But while some have expressed disappointment at these limited achievements, initial state practice reflects a much higher level of enthusiasm. So over the next 2 decades, states concluded 120 new treaties providing for arbitration and brought 14 disputes before tribunals constituted by the PCA, making that institution the center of gravity for interstate arbitration. But unfortunately, the PCA's growing popularity soon exposed its own limitations. As the number of cases increased and became simpler to track within a single institutional process, it became clear that tribunals saw their mandate as resolving a particular dispute, not developing a coherent jurisprudence. And under these circumstances, the procession of ad hoc tribunals decided each case as if it were an isolated problem, sporadic, never occurring before, and never to occur again, with the result that chaos and chance sat as umpire and arbitrator. Expressly seeking to promote a greater continuity of decisions and the accumulation of precedent, the United States renewed its support for a permanent tribunal during the Second Hague Conference of 1907. And while the proposal drew a surprising endorsement from the German delegation, an unforeseen rift opened between large and small states on the principles for judicial appointments. Unable to reconcile the conflicting views, negotiations for a permanent international court ran aground on this single issue in 1907. Now, despite plans to complete the project at a third Hague Conference, the intervention of the First World War tainted the Hague system as a venue for international organization. And yet, the unprecedented destruction gave new impetus to calls for judicial settlement, which the League of Nations recognized by instructing its council to formulate plans for a permanent international court. To that end, the Council summoned an advisory committee whose work became the direct continuation of the Hague Peace Conferences. To begin with, 4 of 10 committee members had participated in the Hague Conferences, including Elihu Root, who as Secretary of State had instructed the U.S. delegation to seek a permanent court in 1907. Despite plans to meet in London, committee members actually gathered in The Hague after the Dutch government drew attention to the undying memories of the peace conferences and invited them to complete the work left unfinished in 1907. To greet them in that historic city, the Council dispatched Léon Bourgeois, a former French prime minister and president of the Commission on Pacific Dispute Settlement at both Hague conferences. And in addressing the committee, Bourgeois called for the establishment of a permanent court, a true permanent court, having the mandate and duration needed to establish a real jurisprudence. And to that end, he expressed the hope that the committee would at least start with the reports of the Second Hague Peace Conference. And building on that admonition, Elihu Root proposed a resolution designating those reports as the foundation for the committee's work, which the committee accepted in substance and therefore completed its task in the remarkably brief period of less than 5 weeks. Over the next 2 decades, the PCIJ rendered 32 judgments in contentious cases and 27 opinions in advisory proceedings. And while most of those decisions involved relatively technical questions and did not prevent the outbreak of World War II, they stood out for their high quality and the unprecedented accumulation of precedent by an international tribunal. Thus, the PCIJ represented a tremendous advance, not by preventing war, but by producing volumes of a coherent jurisprudence that for the very first time in history marked case law as a significant foundation in the development of international law. Although the outbreak of World War II forced the PCIJ to suspend its work in 1940, the court's strong track record guaranteed that it survived with reputation intact. Thus, while the San Francisco Conference ultimately led to the establishment of a new International Court of Justice, the Charter's drafters spared no effort to preserve continuity with the PCIJ at a functional level. For example, they constituted the ICJ under a statute almost identical to that of its forerunner, down to the numbering of the articles. Furthermore, the ICJ established its seat in The Hague, moving into the same premises used by the PCIJ, where it employed the same staff members and exercised jurisdiction under treaties that referred to the PCIJ. Even the leadership of the World Court did not change. The last president of the PCIJ became the first of the president of the ICJ, and from that time on, the ICJ has applied the PCIJ's precedent interchangeably with its own, maintaining a continuous jurisprudence for over 85 years. And thus the court has satisfied the goals of its architects by transforming adjudication into a permanent engine for the consistent and progressive development of international law. Now, reinforcing the triumph of judicial settlement, many observers have already discussed the declining stream of interstate arbitrations and the proliferation of international courts since 1945. And while the transition from arbitration to judicial settlement thus seemed almost complete by the early 1990s, demand for the PCA's services increased dramatically in the last decade. And contemporaneously, the number of arbitrations brought against states under investment treaties jumped from single digits to many scores of pending claims. While surprising to many, the revival of arbitration for particular categories of disputes might not have surprised proponents of judicial settlement who literally fought for preservation of the PCA in 1907 and in 1920. Emphasizing the need to maintain parallel institutions, they explained that judicial settlement would lend itself to purely legal disputes, but that arbitration would remain popular for disputes having a political nature. And to understand the distinction, one must explore the character and limits of judicial settlement contemplated by the architects at the relevant time. In 1907 and 1920, supporters of an international court clearly favored a judicial body having the continuity required for progressive development of international law. But they also sought to ensure that the court's bench would represent the world's major juridical systems in a literal sense. Thus, the court would not merely have a diverse bench, but would be elected and would have a mandate to develop legal principles for the benefit of mankind. Now, as a result, judicial settlement tends to enlarge the range of interests brought to bear on the decision of controversies. For example, arbitral tribunals with no continuing existence, no affiliation to international organizations, and no capacity to affect the legal interests of third states tend to see the disputing parties as their sole audience and the resolution of the dispute as their sole task. By contrast, as permanent tribunals with an elected and representative bench, with links, organic links to international organizations, and with mandates to develop a jurisprudence for the benefit of mankind, international courts will not see the disputing parties as their sole audience, nor resolution of the dispute as their sole task. And this broader orientation may not appeal to states for certain categories of disputes. In fact, Léon Bourgeois identified a category for which all states, large or small, would find it essential to take a more active part in choosing their judges. Thus, according to Bourgeois, states would choose arbitration for controversies of a political nature, which he defined in 1907 as including all cases of a peculiar gravity. Somewhat later, Elihu Root indicated that judicial settlement might prove impossible for disputes governed by broad principles that essentially required the exercise of discretion and political judgment. And likewise, when addressing the advisory committee in 1920, Bourgeois echoed the view that precise and defined legal norms might represent the condition precedent for judicial settlement. Now, these insights help to explain the otherwise puzzling reluctance of states to embrace judicial settlement for investment treaty disputes. When discussing the topic, one should recall that most investment treaties entail bilateral arrangements that promote the flow of capital roughly from north to south by providing guarantees against harmful measures directed at foreign investment by host states. To secure those obligations, most treaties permit investors to submit claims for alleged treaty violations to ad hoc tribunals formed under the ICSID Convention, ICSID's additional facility rules, and less frequently under the UNCITRAL arbitration rules. But as should be manifest, investment treaty thus proceeds under a system redolent of the PCA. Like the PCA, ICSID comprises a list of arbitrators, a small secretariat, and a set of procedural rules. Like the PCA, ICSID became a center of gravity for arbitration of claims against states. And like PCA arbitrations, the recent proliferation of investment treaty claims has exposed the inability of ad hoc tribunals to promote the coherent development of international law. And just as a popular movement sought a permanent court to avoid the vicissitudes of PCA arbitration, a rich vein of scholarship now seeks inauguration of an appellate or other judicial body to increase the coherence of outcomes for investment treaty disputes. Now, despite this robust sense of déjà vu, investment treaty disputes appear unlikely to repeat the historical leap from arbitration to judicial settlement. In fact, surveys conducted by ICSID and the OECD reveal that states have little enthusiasm for judicial settlement in the context of investment treaty disputes. But despite the lost opportunity for harmonization of jurisprudence in investment, a field that craves certainty, the reluctance to embrace judicial settlement makes sense if one accepts that states prefer arbitration of political disputes. Applying the criteria previously discussed, namely grave issues and broad principles requiring the exercise of political discretion and judgment, one can identify the strong political elements embedded in most investment disputes. Many claims place hundreds of millions of dollars in controversy. Some threaten literally to bankrupt states following periods of economic, social, political turmoil, and virtually all involve important points of principle that emerge from existential and unresolved conflicts about decolonization, industrialization, socialist revolution, nationalism, racism, protection of the environment, and the rise of multinational corporations. Furthermore, one should observe that many principles of international investment law lack a precise, defined, and universally accepted content. For example, in 1964, the U.S. Supreme Court implied that it could not identify a clear prohibition on uncompensated takings under customary international law. More recently, a series of negotiations for multilateral investment treaties has collapsed without reaching agreement, including serious efforts by the OECD, the WTO, and states within the Americas. And while capital exporting states have established some governing principles by concluding roughly 2,500 bilateral investment treaties on broadly similar terms, those instruments express many commitments at such a high level of indeterminacy, and the rules of treaty interpretation provide so little concrete guidance that they leave unresolved the essentially political tasks of specifying obligations and thus allocating tremendous risk between investors and their host states. Now, given these facts, let me conclude by saying that one begins to understand the reluctance of states to embrace judicial settlement for investment disputes. Because they raise grave issues, and because they force tribunals to exercise discretion in allocating tremendous risks, they teem with the political elements that Bourgeois predicted would make judicial settlement an unappealing option for states. In other words, while states appreciate the value of judicial settlement in promoting the development, consistent development of international law, they may prefer to narrow the range of interests brought to bear on political disputes by selecting arbitration, even when that means sacrificing stability, coherence, and certainty in the development of international law.
Thank you very much. Thank you all. We have three really interesting papers on the exact topic of the panel. That may be a first in conferences. I've been to a lot of conferences, and I'm not sure I could say that about any other panel. And all of them delivered in the specified time. Something in the air here. The floor is open for comments or questions. You may choose to direct your comment or question to a particular panelist or to the panel in general, and then we'll see who wants to respond.
Could I ask
Yes.
if I could ask Chris a question about his statement that the expansion of arbitration in international matters is not documented. I mean, I think if you speak to any Wall Street firm, to White & Case, to Baker & McKenzie, to the 155 signatory states, to the New York Convention, to new forms of institutional arbitration, CTAC, the Stockholm Center. I mean, this is a multi-billion-dollar business that is not contained and won't be contained. So I mean, other than an academic forum to sort of sharpen your skills in counting, I mean, I don't see what the issue is. I mean, this is a huge multinational business that is thriving, and to say it doesn't exist to me is almost, well, it's
Right.
It's curious.
Can I clarify what my
Yes,
principal
yes.
point was? I certainly wasn't trying to suggest that there is, that transnational arbitration is not on the rise. What I'm interested in is this relationship and whether or not it's displacing litigation. And there is some, I think that there's some, I think both of the survey of the Fortune 1000 companies and the study, the Claremont-Eisenberg, the Eisenberg-Miller study, at least make us wonder how pervasive it is.
Yeah, but that's
So
done
I'm
by
not trying-
CPR. CPR wants to promote mediation. I mean, it's a, these studies, I'm not sure are scientific, I'm not sure they're disinterested, I'm not sure they're acceptable.
Right,
It's a very peculiar position to take, that that somehow arbitration is not dominant. I would never advise an international client to do it any other way than by arbitration. And the ICC's business has gone from a few hundred cases to 650. CTAC, because of the corruption in the Chinese system, has declined, but that's not true anywhere else. So it's.
Do you think as arbitration is becoming more judicial in its process, do you think that there may be more recent trend to resort to litigation under circumstances that one might?
That's an interesting question, but I think there are two lawyers at Baker and McKenzie, Larry Newman and David Zaslowski, who just wrote a piece about there is still the common law, civil law fight in international arbitration. And the continentals or the civilians won't accept the U.S. methodology, and therefore de-judicializing arbitration is much stronger than we think, although the influence of Wall Street lawyers has had a huge impact on arbitration. I'm not convinced that arbitration is necessarily judicializing in all its aspects.
Okay, I think we've sharpened that issue. It's time to open the conversation. Yes, sir.
Yeah, I think it is cyclical. Also, one has to look about the size of cases. Let's take out labor, small investors, and consumer cases. Let's look at the professional sphere, the professional arbitrations. And let's also look at the courts. I mean, it often comes as a surprise to people to find that the commercial court in London, in the High Court, has only 50 to 60 cases a year, no more. In arbitration, we have very large cases, and that makes for the involvement of the major law firm. But how many? I mean, the LCIA and the ICC, of course, there are many cases filed, but most cases filed never get any further. How many active cases are there? And that is, people often say this is a secret, but I think it is just not known. And from year to year it goes up and down quite a bit. It is quite clear that in the international arbitration community, there are not thousands of cases out every year if you take out the consumer. And but if you limit it to the commercial sphere, there are not thousands of cases every year. I mean, it is in the hundreds that are being decided. Now, they are huge cases. I mean, my largest case has been in the billion, and I was a little frightened. But
You didn't have to pay personally, you know.
Yeah. So numbers, I think, are limited. Because why? Commercial parties, professional parties are not so stupid as just to litigate for litigation's sake. I mean, it's very expensive. And so they try to limit it quite naturally. And in good times, at present, there are fewer cases. Why? Because business is cash rich, and so they settle. In more lean times, you will find somewhat more litigation. When I was a general counsel, I would go to my boss at the end of the year, the top man, and say, well, how rich are we? I said, well, do you want a bonus or what? No, I said, well, I want to know which cases we can settle this year, and if you are not rich, well, I will try to push it in next year. Or and so but many cases, I don't think, no, but big cases, yes.
These are falsifiable propositions, of course. That is to say, they could be researched. The cyclical character and the relationship to the cash richness of the company.
As Tom says, I think law firms, the major law firms, are really the ones who know the best.
So do the forums. So do the forums.
If I could add, there was an ICC study of international arbitration recently that indicated that 76% of the cost of an international arbitration are lawyer fees. So the lawyers live off of this in a very handsome and lucrative way. It's a huge business. There's no doubt that it's mega cases, but it's still a huge part of practice. To send a client to domestic court, to me, is an act of legal malpractice, because you can twist that until the next asteroid hits the Earth, because you can never stop litigation.
Ernie.
I want to ask a
Neanderthal question about this idea of replacing the litigation system with this parallel private judicial system. I teach constitutional law and procedure, and
A little louder.
I spend
so
a
we
lot
can
of
hear you in the
time
back.
thinking about the legitimacy of courts, the checks on courts, the accountability of courts, the fairness of the procedures, all of this carefully regulated, carefully thought about hundreds of years. What is legitimate about a parallel judicial system that doesn't have those checks, doesn't, is it just in terms of its effects?
If you want my answer, the real answer, well, there's a twofold answer. One is the U.S. Supreme Court, because the U.S. Supreme Court has decided that subject matter inarbitrability is no longer a limitation on arbitration. I mean, literally, there are cases where the court says if there's even a makeshift reason to identify a contract, you're going to arbitration.
Why is that okay?
Because the U.S. Supreme Court, other than by congressional
I mean,
repeal.
not those guys. Them saying so doesn't make it okay, right?
But what makes it legitimate for you to say, I'm going to define legitimacy by saying whatever I look at? I mean,
have a theory of popular consent
yeah,
under the Constitution.
the justices have a real responsibility, unlike law professors. And their real responsibility is to deliver adjudicatory services to the widest number of citizens and to have a decently fair system. And the system is self-regulating in the sense that it's responsive to market factors. Now, it's not the federal court system, but who the hell says the federal court system is any good? I mean, you have a bunch of political appointees, you can predict how they're going to rule on major issues on the basis of which president appointed them, and this is supposed to be a fair, disinterested system? I mean, and I think our activity of swirling around what judges have said is a very narcissistic activity. It's not, I mean, nobody reads the stuff that we write.
Red Scott was right. Red Scott was right.
Look at the dutiful students who are here. I mean, I used to organize this when I was in high school, in law school. And they're here listening to us, and they're very polite, and it's wonderful to have you here. And it's a great duty that you fulfill. But nobody, I mean, the U.S. Supreme Court has to deliver a right of redress of grievances to American society. It has clearly, in 30-odd cases, said that remedy, unless it's criminal, is arbitration. And some state legislatures have now decided that even criminal liability can be subject to mediation. I think that's psychotic, but the trend is to proclaim the bankruptcy of the judicial process. It clearly has been inoperative because it doesn't exist at a transborder level. And domestically, unless this new legislation is enacted, it's failed at a domestic level, I think. I mean, that's...
Professor Brower wants to interject something.
Right. Professor Young, if I can respond slightly differently to your inquiry, which is a good one, I think the legitimacy comes at a number of different levels. There is, of course, party autonomy, the fact that if it's a dispute between two parties, let's say that there are no third-party effects. I mean, that's an assumption, and we'll loosen that assumption in a moment. But certainly if there are no third-party effects, they've made the decision, they are adult competent or entities, and therefore have the power to make those choices for themselves, maybe in a way that's better tailored to their situation than the state's solution to every problem. The second level to that, of course, is now we introduce third parties, and there could be effects, whether it involves these integrity of financial markets if it's securities litigation, or free markets if it's antitrust disputes. Well, then we have statutes, like the Federal Arbitration Act, passed by Congress, and treaties which permit the arbitration by and large, unless you have specific exclusions, then construed by the Supreme Court to provide limits on arbitrability only if it's specifically enacted by Congress, which Congress hasn't done. And then there's a third level of review and legitimacy involved in the sense that every award is subject to review to ensure the integrity of the process. First, to make sure that the parties have had a fair process, and second, to make sure that the solution does not violate the basic norms of the forum where it's being enforced. So I see there are a number of social filtering mechanisms that should give you a little bit more comfort than maybe you had initially.
If I can just follow up, there's a big debate in constitutional law about the allocation of judicial decision-making functions to administrative agencies. And the only way that that gets upheld is by virtue of emphasizing constant supervision and accountability of the agency and constant supervision by Article III courts, which isn't what we get with these very narrow grounds for refusing to enforce an arbitral award, it seems to me. And it seems to me if Professor Carbonneau is right, and I have no doubt empirically that he's largely right about the massive impact of the system, then third parties are, of course, massively affected by this shift in the system.
Professor Brand?
I don't know if it's a question or a comment, and to me there's been one thing missing here that I decided I'm going to try to add to my presentation this afternoon, but that's it's why do parties choose arbitration instead of litigation? And I don't buy the whole thing that it's simply it's so much a better system and the courts are bankrupt. There is, in fact, has been a good deal of work by the ABA and others in this area, and about the need for a system that is balanced between recognition and enforcement of arbitral awards and of judgments. There has been a convention negotiated to accomplish that. And when I talk to people who put arbitration clauses in, the first answer always given is, we put them in because there's a convention that will get the award recognized and enforced. And you simply don't have balance in that aspect between arbitration and litigation. When we negotiated the Hague Convention, that now is the Hague Convention on Choice of Court Agreements, we heard a lot from the bar, practicing bar, that said there are many cases in which we would prefer litigation or arbitration, but we don't have it available. We don't have the enforcement mechanism available, so we use arbitration anyway. Now, so I don't think the imbalance is all one way or the other. I think there are advantages and disadvantages of each system of dispute resolution, but at this point there is an imbalance in the international system because the New York Convention exists and there is no comparable global convention on choice of court and recognition of the resulting judgments.
If I could respond to that, the choice of court convention is testimony to the fact that jurisdiction and enforcement will never be agreed upon by even like-minded states. There's not even a bilateral treaty on the enforcement of English and American judgments between two allied powers. The international sphere doesn't have a rule of law that a merchant or commercial entity can depend upon to seek effective dispute resolution. The New York Convention is a very effective instrument. It works very well in the North American, European context. It is much less effective in the Middle East, in Asia, and in other jurisdictions that are less favorable to arbitration.
The international sphere does have the instrument now. It's newly available. There's one ratification. I think there'll be more coming down the road.
I mean, that's a ridiculous
Dodge.
I was very intrigued by Chris's identification of two perspectives, the dispute resolution perspective, which seems to me to reflect private interests, and the governance perspective, which seems to me to reflect the public aspect of these things. And I wanted to suggest that there's a tension, the tension between the two is reflected in investor-state arbitrations, and particularly in the debate that you're seeing now in investor-state arbitrations about the role of precedent and whether there is a system of precedent, should be a system of precedent between tribunals. And you see some people arguing that no, there shouldn't be, because it's all about just resolving the dispute between the parties. And the only reason arbitrators in that context even talk about prior decisions is because the parties have raised them. And so they have to respond to the parties in that sense. You see, on the other hand, and in fact some recent arbitral awards taking the position that investor-state arbitration is an emerging system, and that is a responsibility beyond the parties, a responsibility to third parties to pronounce rules of law, which can then provide predictability for future disputes and also greater certainty for investors who don't ever end up in disputes. It's a very interesting debate. I don't have any answers for it, but it seems to me it reflects the tension between these two perspectives, which further seems to me to reflect the tension between the public and the private that you see particularly, I think, in this kind of arbitration. And I would just invite any comments from anyone about this area.
Anyone on the panel? Well, then I'll say something about this. The private character of the arbitration, of course, inhibits the development of a fully fledged notion of precedent.
But in the investor-state context particularly, even though technically there's no precedential effect, you are starting to see arbitrators articulate that they have some sort of obligation to follow past decisions. And that's something you don't see in the purely commercial context. And I think it's informed by some of their sense, and this is controversial, but that they are part of a larger system and that their sole responsibility is not simply to resolve disputes.
No, I appreciate that. Well, all I'm saying is that the confidential character of
but
arbitral
those awards are
awards
largely published now, too.
Some of them are and some aren't.
If I could respond, I mean, I agree with Professor Dodge that in state arbitrations there's a bigger presence, more influential presence of legal precedent, but that's also true in commercial arbitration. You're an arbitrator. I'm sure you don't disregard what similar judges said in similar cases. This is not, as Goldman said, law in under a tree. I mean, this is a sophisticated process that is vehicled by major law firms, and if you think those guys aren't going to refer to case law and to precedent and make legal arguments and submit legal briefs, I mean, that's a naive view of what goes on in a multi-hundred-million-dollar case. I mean, precedent is everywhere. It's even true in domestic consumer employment cases, if the AAA would ever release those awards.
Marissa.
Yeah. So I am one of those people who actually does read what you write. And
Thank you so much.
You're welcome. And
I'll sign whatever you read.
I guess this question is for you, Professor Carbonneau, and also you, Professor Whytock. As a student and someone who's going to enter the professional world and is hoping to sort of join this sort of debate from a work point of view, where do we go? What's the future of this looking like? And if, as you're saying, maybe that international arbitrations in particular aren't as popular maybe as legend would have it, or as we are supposed to think that they are, then do you see that it will still continue to grow? And as someone who's sort of entering the field, what might we be looking out for as possible issues in the coming years as things go on?
Can I jump in with something really quick? First of all, I hope I didn't create a distraction by overstating the claim about. I think Professor Carbonneau is right that arbitration may be dominant. What I'm really interested in is how pervasive, where it's pervasive, and so forth. So I certainly wouldn't want to imply that you should not get training that would equip you to possibly. I think the most important thing would be for you to learn how to make strategic decisions on behalf of your client about which form of dispute resolution is best under the circumstances. And you probably would say that 90% of the time, the decision should be arbitrate. I'm not sure that that's always the right decision. I share, I guess, some of the skepticism that it really depends on the circumstances and what your client is looking for, your client's bargaining power. So I think that's something you'd really want to focus on understanding. How do you advise your client to make the best choice?
But I think entree into the field is achieved by way of law firm practice. So there's no other real way to get into it other than by working for a law firm with this sort of practice activity. And the practice activity is phenomenal. I mean, there was Baker & McKenzie has an operation in London, as it has in many countries. The chief partner there broke off from Baker 2-3 years ago, started his own boutique firm, and is doing a thriving business. I mean, it's a growing area, and I think the more you know about major case law, the experience you might have in drafting arbitration agreements, how to choose arbitrators. I mean, there's a lot of very dynamic, vibrant literature that you should consult out there, but it's a law firm activity. And I must say the U.S. legal education process is hardly caught up to the realities of practice, and that's very unfortunate, and it's nearly an unprofessional type of behavior toward law students. But I think the way in is to go to meetings. There are enormous number of conferences on international commercial arbitration, specifically in the Latin American area, and that's the booming area currently, at least as I can perceive it. So there's a great deal of interest, but networking is also very critical. I don't know how else you get into it, because unless you look sort of old, you're not going to get to be an arbitrator for a while. And the going rate for an international arbitrator is $6,000 a day. And some of the English solicitors get $900 an hour. So this is a huge business. I don't know if that's responsive to.
No, and that's helpful. I guess I was thinking more from a theoretical perspective of what you discussed, like what might be some of the sort of critical issues that you see facing these types of discussions and discourses in the next couple of years. Like, you mentioned Latin America, for instance, like, what is it about sort of the interplay between arbitration or decisions and adjudication systems that might be more complicated as young lawyers start to face those types of issues when you're talking about trying to understand exactly why we should read scholarship and why we should have more of a sort of high level understanding about what the conflicts are.
The first issue that any good international lawyer looks at is enforcement. You look at that before anything else. You make sure that the award or the judgment is enforceable where assets are located. I mean, that's the first issue that you deal with. In terms of glamorous issues, tribunal-wide neutrality of the arbitral tribunal, whether there are amicus briefs available, what the role of precedent is, are other cutting-edge issues. What level of evidentiary proof do you adopt? I mean, all of these things are part of an informed arbitration agreement. And there's a good book by Paul Friedland on drafting arbitration agreements. He's the chief guy at White & Case in New York on arbitration. But writing arbitration agreements is...
Time for one last question. Ralph.
Sorry, it's lunchtime, but I really have to ask that. What's the difference? What's the difference between state courts and arbitration? What's the difference for two Islamic parties, whether they go to commercial court in England, which is foreign to them, or whether they go to an arbitral tribunal that is elsewhere? Beyond, of course, the secondary things like lawyers make more money in arbitration, but it may be faster, etc., etc. The thing that I used to think, or that is often argued, is to say that commercial arbitration is good where you have commercial, technical issues, and you need the states' courts where you have actual political issues. But then we find on the one hand that arbitration deals with all these political issues now. And in fact, we find from what Chip says that states in some way prefer arbitration over courts precisely where they deal with political issues, because they say they can more easily be resolved in arbitration that can go beyond just the law and deal with these political aspects versus the law. So my question coming back to that, and including questions of developing precedent system in arbitration and developing institutionalization with the ICC, etc. Why should we view one as essentially private and the other one as essentially public? Shouldn't they really be viewed as very similar? And that's to all of you, and I'm sorry that prevents lunch, but that's really unnecessary.
It's all right, there'll be a brief answer.
For commercial arbitration, and this is the only context in which I'm speaking, commercial arbitration, it's a public-private partnership, because arbitration only works with judicial support. And so I don't see them as hermetically sealed, as you suggest, but you can't have arbitration without courts that are willing to enforce arbitration agreements, enforce arbitration awards, decide challenges, review jurisdictional decisions of the arbitrators, and things like that. So it is a much more, it's a relationship and partnership much more than one or the other.
And I'd agree. I'd say the same for arbitration and for litigation, that in litigation, I'm not sure how widespread this is now, but a state court could, in theory, apply contractually agreed upon norms. There's discussion of state courts starting to apply non-state norms. So even on the litigation side, and the whole fact that litigation is initiated in the first instance by private parties, I think there's a private dimension to litigation that, so I think litigation is mixed and as well as arbitration.
I think the reason that a Saudi party or an Indonesian party would go to arbitration if they did business with an English company is simply for the purposes of neutrality. I mean, you don't want a state-driven solution to mixed nationality disputes, so arbitration offers neutrality, expertise, and enforceability. And that, I don't think any state court can really offer you at an international level. And as to law applicable, it's such a complicated issue that we'd have to skip dinner and not just lunch.
And don't forget, you get to choose your own judges, too.
Yeah, right.
Which is a non-trivial point that has been insufficiently emphasized. Anyway, this was a great session. Thank you all very much. Thank the audience very much. And it's time for lunch.
Briefly, my name is Melanie Jones. I'm the managing editor of the journal here, for those of you who don't know me. And my most important role today is that I am the lunch lady. The lunch is outside. Grab